Number 67, People v. Carlos David.
Good evening again, Your Honors. Once again, Guy Talia on behalf of Appellant Carlos David. I'd like to reserve 3 minutes for rebuttal, if I may.
Yes.
So at the outset, I'd like to note that we are making a facial invalidity challenge that is distinct and separate from any of the arguments that have come before us today by any of the appellants. It does not depend on, the validity of it does not depend in any way, shape, or form on the invalidation of the proper cause requirement. It is based upon the foundational holdings of Bruin that led the court there to invalidate the proper cause requirement, and that is the extension of the Second Amendment for the first time to carrying a loaded weapon outside your home, and also the new test that it articulated for determining whether any restrictions on that are valid. Now, there are serious but uncomplicated consequences of that extension. The prime one that we're relying on is that it substantively prohibits the state from defining the mere possession of a firearm outside your home as a crime. Section 265033 defines the mere possession of carrying a firearm outside your home as a crime. And my client was convicted on proof of nothing more than carrying a firearm outside his home. Now, the fact that there is an exemption and that the licensing provision could have relieved him from that liability.
Your position is that licensing is not an element.
Correct, Your Honor, that's exactly our position.
And there was a
it
failure
should
to
be.
charge that element, that the jury had to find that element to convict your client, right?
The jury did not have to find that element to convict my client.
Why isn't it obvious from Hughes that it is an element?
Why isn't
From
it
Hughes,
obvious?
that it is an element?
So,
Why weren't we clear there? Why wasn't the court clear there that what is criminalized is not someone carrying a gun, someone without a license carrying a gun?
sure, yep. So Hughes did state that it is not merely possession, but unlicensed possession, that's a crime. And we do acknowledge that that was at a time that Heller existed and it involved in-home possession. But the reason why Hughes does not foreclose our argument here is because that was not an issue in Hughes. The court was kind of observing, it read the statutes together, it cited both 26503 and 26520A3 for that proposition. So everyone admits that when Hughes made that statement, which was not an issue in the case, I mean, the case was about whether the sentence can be enhanced by a prior conviction. So the plaintiff or the defendant in Hughes never made the argument that there was an improper burden shift or that there was a due process violation because he was convicted on non-criminal conduct. He accepted his conviction and assumed that the state could prosecute him, that there was no problem with the burden shift there. So it observed that, but the issue wasn't squarely before the court in Hughes, and so I don't think that you can consider that a holding in Hughes. And the same issue actually occurred in Guardado in the Massachusetts
I'm
court.
sorry, you're saying that at post-Hughes, it was an open question as to whether or not licensing is an element of the crime of possessing unlawfully a gun outside, public carry, that it was an open question?
Yes, I mean, I don't think it addressed the open carry at all. It was addressing in-home.
That's what I'm saying, it left that question open,
Yes,
whether or
absolutely.
not what the legislature intended to do and what the language of the statute does is criminalize public carry regardless of licensure.
I think, to answer your question, the first question, it was an open question after Hughes, yes, absolutely. It was not definitively decided by the court in Hughes that Hughes did not make the unlicensed aspect an element of the crime of 265.033. It merely observed that if you were possessing, you have the opportunity to raise as a defense licensure, and you can relieve yourself of that liability. But it wasn't saying the court couldn't read into 26503 an additional element, and that's why it cited both provisions when it did make that observation.
Could a defendant stipulate to the lack of a license and therefore create a situation where the jury would not need to be instructed that it had to find the lack of a license? In the same way you might, for example, stipulate to a prior conviction without having to prove it.
Well, I don't think a stipulation would be necessary because the jury is not instructed on licensure at all. The jury, our whole argument is that the jury.
No, I mean, going forward, could a defendant stipulate to a lack of a license, or is it your position that a jury has to make a finding either way?
Our position is that the lack of a license is an element that has to be pleaded and proven by the state. I don't know why a defendant would stipulate to the lack of a license and then subject himself to that crime.
Well, that
Because
proof
let's say
could be
that-
circumstantial evidence. It need not be, right, an admission. It need not be anything other than what might otherwise be sufficient circumstantial evidence.
I'm not sure I'm following your question, Your Honor, but our position is
Well,
that the,
I guess, what way would the government prove is what I'm talking about. So it strikes me that there's no reason to carve a distinction out here for this particular crime. You can prove it through circumstantial evidence.
well, the point is they
Said
don't have
what-
to
no,
prove it at
You can't
all.
envision that a defendant would stipulate, would
Well-
concede that they had no license, let's put it that way. So I'm saying you might not necessarily need that from the defendant. You could have some other way of proving, right? Circumstantial evidence, there could be reasonable inferences that the prosecutor might argue, establish this lack of licensure.
Well, there's many ways you could probably establish the lack of licensure,
Sure.
but the problem that we're arguing is that there is absolutely nothing right now, no reason for the state to do that at all.
Yeah, but shouldn't he have produced a license? The 400 requires a production of a license. So is that burden of production a burden shift? Is that what you're arguing?
We're making two arguments, Your Honor, yes. So the first argument is that because the state is substantively prohibited from defining the mere possession of a firearm in public as a crime, and that's all that 265.033 requires, that it's a due process violation to basically convict him only on proof of that alone, because you convicted him of conduct that's not criminal. It can't be criminal anymore. Now, there's respect to the burden of production. Once once a state is substantively prohibited from defining conduct as a crime, it can't shift the burden to the defendant as a defense to say that they're relieved from that liability or they're subject to an exception.
Well, that's the question, is which burden can't they shift? Both burdens, production and proof, or just proof?
We are arguing that it's both burdens. They cannot shift the burden of persuasion or even production in this case. And that is because the nature of a defense is to justify conduct that is otherwise permissibly prohibited. Let's say the state is permitted to generally prohibit public carrying, which prior to Bruin, it was, and that's what it did. And then the nature of the defense is to say, oh, well, I'm justifying conduct that is otherwise, the state may otherwise permissibly prohibit. But when the state can no longer permissibly prohibit the public carry of a loaded firearm, all burden shifts are off. They have to plead and prove not only the possession, but also the reason making that possession unlawful. And the reason making that possession unlawful is either you're unlicensed or you're subject to some other disqualifying factor. So our position is that you cannot shift either the burden of production or persuasion in these circumstances. Now, Mulaney, is cited by the Attorney General, is arguably the only case where you could say that they allowed a burden of production shift on what they can solve an essential element of the crime. But Mulaney, I would note, and the distinction there is that the conduct at issue there was otherwise, the state was well within its right to prohibit the intentional killing of someone, and then they chose to add an additional element and the definition of that crime. And in that situation where the state was allowed to permissibly prohibit the underlying conduct, it was a little unclear, but it seems like they did allow them to shift the burden of production to the defendant to say, oh, well, I did it under extreme emotional disturbance, and then the burden would go back to the state. But here we have a completely different situation. After Bruin, the state can no longer permissibly prohibit the mere possession of a weapon outside your home. They have to prove something else, something more making that possession unlawful. And in that situation, I think the case law is clear. As Bailey, McFarland, Morrison, all Supreme Court cases all make that point quite clearly. I think when the underlying conduct, the state may not permissibly prohibit that conduct. They can't shift either the burden of production or persuasion. And that applies even with the comparative convenience test and with the rational connection test. So in light of that, we feel that, the conviction needs to be reversed and the indictment dismissed. I can address preservation issues if I may. I still have a little bit of time, I see. So the futility argument has been discussed extensively today. I mean, we have that as well, but this also has the mode of proceedings, the fundamental organization of the courts under Martinez. Convicting someone on conduct that cannot be defined as criminal, there's nothing more fundamental to the organization of the courts than doing that. That's the Martinez case. And then this also falls squarely within the mode of proceedings in Patterson. The exact issue in Patterson was, did he get the procedure mandated by law? And that was a burden shift. They said, is the state required to prove this as an essential element, or can they shift the burden?
Wasn't that a shift there in both the burden of production and the burden of proof?
It was, Your Honor, it was. Patterson shifted both the burdens, but in terms of the mode of proceedings error, that's a distinction without a difference. So it's still the operational.
Why doesn't it make a difference? I'm sorry. I think it was the same question.
Well, because in terms of the mode of proceeding, he's entitled to the procedure mandated by law. And in this case, as I just explained, we don't think they can shift the burden of either production or persuasion. So the procedure would be that the state needs to prove all the essential elements of a crime that's under Winship. And Patterson involved persuasion, but in terms of the procedure, it's the same. If you can't shift the burden of production or persuasion, it's the same procedural problem.
What's to say that the defendant in this scenario can't put into issue the licensure, which is the burden of production, not really the burden of proof? No one's denying that, if there's an issue in the case, it's the people's burden to prove it, but why can't we ask the defendant to put the people on notice that they have to do that?
I think that goes to the things that I've stated so far. It's a violation of the principle in Winship that says the state must prove all the elements of a crime beyond a reasonable doubt. And if you shift the burden of even production to the defendant to produce a license, the state is relieved of that burden to prove all the elements. Because if we all agree that only unlicensed possession is unlawful, then we're saying the state has to prove possession and that it was unlicensed or some other disqualifying factor.
Let me ask you, perhaps it's obvious, but do we have to actually get to that question? Because if there's no instruction at all about licensure, forget about who's carrying the burden, just no instruction at all to the jury that you've got to find that the defendant did not have a license, doesn't that end the issue? Isn't that enough for you to prevail on this question? Do we have to get to this question of the burden shifting?
No, you don't.
If we agree it's an element?
Right. Your Honor, they're exactly correct. I mean, that's the first core part of our argument. The inquiry can arguably end there.
But did you have to object to the jury instruction? Especially if it was unclear whether this was an element or not.
Well,
You have an obligation to preserve, because we said you have an obligation to preserve objections to jury instructions, right?
Yeah, I believe that is correct, Your Honor, but here, there would be no grounds to object to the jury instructions because it was clearly the procedure in the state, as
But
evidence
had
by Hughes.
we ever made clear that that was sufficient, that you could prove without proving a license given use? Have we said that? Had we ever said that? That you could do what they did here?
That to convict without proving an element? No, I don't believe this court has ever said that could be done.
Have we ever said you have to,
No, I don't think this
that,
issue
that,
has been
that,
addressed before.
that a conviction can stand if an element wasn't charged to the jury, regardless of whether or not you preserve an objection to the lack of an instruction?
Exactly correct, yeah, it cannot stand. Someone cannot be convicted on proof of conduct that cannot be defined as criminal, which is what happened after Bruin.
Do we have a case where we've said you don't have to preserve an objection to that type of jury instruction? I mean,
Well, I'm
I
not
know there's
sure.
a federal case that says exactly the opposite in terms of a very similar issue, that if you want to insulate your convictions, then enforce the rule about objecting to the jury instruction.
Well, I'm not sure what exactly the objection to the jury instruction would be here. I mean, it would be, I guess,
Not charging a crime.
well, like I said, this goes back to there were no grounds to make that objection prior to Bruin. Prior to Bruin, I think it was widely accepted that the process that we're complaining about now was okay, because prior to Bruin, there was no constitutional fundamental core right to carry a handgun outside your home. It was freely regulated by the state. So the state, prior to Bruin, fell in the category of the state's ability to define how they want to prosecute their
If we
crimes, including
disagreed,
burdens
if we
of production.
disagreed in your interpretation of Hughes and thought that Hughes made it clear that this is an element, would you then have had to preserve?
Well, I find it hard to answer that question because I don't see Hughes as saying that this was an element. If Hughes said that this was an element, I don't think it could have allowed the burden shift, or it would be a different problem with that conviction if Hughes said it was an element. And I don't think Hughes, like I said, can't rewrite the statute to include an additional element. It was reading two statutes together, and the consequence of it being in two separate statutes is the burden shift. So I'm not sure if that answers your question or not, Your Honor, but.
Thank you.
Thank you, Counsel.
Thank you, Your Honors.
May it please the court, good evening, Your Honors. Lisa Gray for the people. Just with respect to the Hughes matter, Hughes was pretty clear that, a person who possesses, a person who has a valid license commits no crime. And it's our position that 265.03 sub 3 read together with 265.20, which is a proviso, the people don't have to plead in the first instance lack of licensure in order to establish all the elements of 265.03 sub 3.
Even post-Bruin?
Even post-Bruin, because unlicensed possession of a firearm is not in public. Unlicensed possession of a firearm in public is not constitutionally protected conduct under Bruin. Bruin said ordinary law-abiding citizens have a right to publicly carry firearms. In this case, Mr. David did not have a license, and he carried his unlicensed weapon in public, he actually had two, in his motor vehicle. He was engaging in conduct that was not constitutionally protected even after Bruin.
So it's the intention of your office to continue to charge CPW and go to trial in these cases without proving as an element of your prima facie case that the defendant lacked a license?
We don't have to prove lack of licensure because 265.20 exists. Because if the person who is suspected of possessing an unlicensed firearm has a license, present that license. It's a bar to prosecution.
Otherwise, and if not, we get to assume that you didn't have one.
Correct, which I think kind of goes to your point a little bit, Judge Halligan, when talking about a stipulation. We don't necessarily need a stipulation because 26520 exists.
But doesn't that really sidestep the question of whether or not the lack of a license is an essential element? Because otherwise, I think one could read Bruin as saying that public carry is presumptively protected.
Of an ordinary law-abiding citizen. And I think,
But what makes, it seems to me, if I'm understanding your argument, that what makes the citizen, in your example, not law-abiding is the lack of a license.
because they did not submit themselves to the licensing scheme.
And so I'm not sure I see, maybe you can help me, how the fact that the person is therefore not law-abiding advances the ball in terms of whether the lack of a license is an essential element or not.
There is a circularity to the reasoning, isn't there?
I mean, I think when we're prosecuting CPW statutes, 26503 sub 3 and 26520 go hand in hand. I've never come across a case where somebody has been prosecuted under 26503 and they've had a valid license. They've carried a lawfully licensed loaded handgun in public and was still prosecuted under 26503.
But I'm not sure that answers the question, or maybe I'm missing it, and I realize that it's also late in the day. I'm not sure that answers the question of whether or not the lack of a license is an essential element. I understand your point, I think, about how the ordinary defense works in operation of 26503. But what about whether it's an essential element?
I'm trying to choose my words carefully. The lack of licensure is not an element in our statute. It's criminal possession of a weapon. Unlike some of the other states, there was a reference to the Massachusetts case. That is unlicensed possession of a weapon. I might be paraphrasing a little bit, but the word unlicensed appears in that statute. In New York, it's criminal possession of a weapon.
But isn't the point it can't be criminal if you don't show you don't have a license? I mean, I think their
it's so
argument, if
minimal.
I boil it down a little, is what we used to criminalize in New York before is now not only not criminal, it's constitutionally protected conduct. So in order for you to prove a crime, you need to prove the unlicensed element. Otherwise, all you're proving is someone exercised their Second Amendment right.
But when the person who's accused of criminally possessing a weapon in public, they can present their pistol permit easily. They can, that burden of production, that production is so minimal, it's so small, and it serves to then, ultimately, ultimately would bar any then further intrusion, an arrest, or any subsequent litigation.
It's just, even if that was the way to approach the question, it's just as simple for the people to make the argument you're making now as circumstantial evidence. Never produced a license, you didn't find it on the wallet, you didn't find it anywhere in their vehicle, you didn't find it on their person, correct? Okay.
But it's just as simple for investigative purposes, for the person who has that gun in public to produce that license when it's found in the
understand that.
glove box.
I understand that. Okay, so just to be clear, your position is that post-Hughes, it was either absolutely clear that this was not an element, or it was not certain that it was an element.
It's my position
You
that
agree
it
with
was
him
clear it
that
wasn't an
Hughes did
element.
not decide that licensing is an element?
Hughes did not decide that licensing is an element. That's my position. That
So you agree with him?
lack of licensing is not an element for criminal possession of a weapon
Okay.
in New York.
Okay.
Even now.
even now, because it's still, I think I've said it now 3 times, but it's still unprotected conduct, because Bruin spoke only to ordinary law-abiding citizens who, when they went to go apply for their public carry permit, had to then go sort of jump through this extra hoop of proper cause to, obviously establish an elevated need for public carry. But again, it didn't speak to the criminal statutes. And Bruin didn't, it didn't magically decriminalize criminal possession of a weapon in the second degree here in New York State. People still have to submit themselves to licensing schemes. Now, they have to be constitutional, and Mr. David, he didn't do that.
So you say then it's a defense? Your point?
I don't,
That it's a
I don't.
defense?
I mean, it's a bar to prosecution. I don't know that it's necessary, it's an ordinary defense. It's a bar to prosecute, it's a proviso that exists outside the statute. It is, lack of licensure is not an element for criminal possession of a weapon in the second degree. And even post-Bruin, it still exists that way. Bruin did not affect.
I am having difficulty understanding this distinction that you're making, that it's not an element, but you can't prosecute unless they're unlicensed.
Because it's such a minimal thing for the accused to do. Show us your license, and we can all go on our way, and you won't be criminally
Sounds to me
prosecuted.
that means the nature of the crime is if you're unlicensed, you're in criminal possession of a weapon.
Well, again, it has to be read in conjunction with 26520. It is possession of a weapon, not outside your home or place of business, but it's a barred prosecution if you've produced your pistol permit for that particular firearm that you're possessing in public. And, Mr. David didn't have a pistol permit for either one of these firearms. He certainly didn't produce anything to indicate that he had them. He didn't submit himself to any licensing scheme, So, the people's position is that, none of these, I certainly don't want to go back to preservation and standing. The court has heard, I think, almost every single argument to be
Can I
made.
ask you one specific question
Sure.
on preservation? If I am understanding correctly, tell me if I'm not. I believe that the defendant looked to file a supplemental brief in the appellate division. Is that right?
Oh, Judge Halligan, I think you got me on that one. I
was trying to understand if that was
Okay.
correct, how that might affect our understanding of preservation.
Okay, I'm unaware of his attempts to file any supplemental brief at the appellate division. I am unaware of that. Going briefly with respect to preservation and whether or not lack of licensure is an element of the crime, to your point, Judge Garcia, there was no objection to the jury instruction. There was no trial order of dismissal that perhaps the defense attorney could have raised to say the people didn't put forth prima facie evidence of a crime. They didn't put in sort of any evidence with respect to lack of licensure. The defense counsel never did any of that. So so it is unpreserved. These claims are all unpreserved on many levels. And unless there are any other questions, I think that's it. Thank you.
Thank you, Counsel.
There you go.
May it please the court, Andrew Raymond again for the Attorney General. Defendant Carlos David's statements that were part of the people's case in chief in this prosecution were flatly inconsistent with his having a license for those guns. In New York, handgun licenses are particular to the weapon. They have to specify, among other things, the caliber, make, model, and serial number for the weapons.
And what do you say about it being, whose burden is it after Bruin?
Our position is, and I'll explain this, it is the defense's burden to put licensure in issue. Bruin did
Well,
not...
if having a license is a bar, why don't the people have to establish that he doesn't have one?
The way that New York has long, this court has long interpreted its statutes, including for criminal possession of a weapon, is that if the defense is, or if the offense and provisos that provide an exemption from prosecution for that offense are located in different statutes, that is what that puts on the defendant what is called an ordinary defense.
But
They
isn't the
have to put it in
question
issue.
whether that's permissible in light of Bruin, if we conclude in light of Bruin that the lack of a license is an essential element?
It would be, no, it wouldn't. I would also say that, what my client, or what my adversary is assuming are a couple of things. One, that New York is, through this mechanism, actually punishing lawful, licensed, or otherwise authorized conduct. It is not. When police arrested the defendant here,
Okay,
it was
but
clear that...
accepting that
Yes.
that's certainly not their intent to punish otherwise lawful possession, why isn't it the people's burden to prove that I'm not lawfully carrying it because I don't have a license?
Bruin did not establish, and Bruin itself was clear about this, the right to have any weapon at any place in any manner. It is subject to restrictions by the state.
No, I agree with you there, but I'm asking you about, you did say, or are you disagreeing that absence of the license is what makes it a crime?
Absence of authorization, of which licensure is one type, but of which there are many different categories, all of which, the people would, I think, under defendant's reasoning, have to disprove. And there's nothing in Bruin that says that a state which can impose all of these lawful restrictions cannot enforce those restrictions by saying carrying a weapon is a crime unless you have an exception, and then placing a minimal burden of proof.
Why is it a minimal burden?
Pardon me, not burden of proof.
Why is it a
burden of-
minimal burden on the defendant and not the people? They have licensing apparatuses all over the state. I'll admit that they're different, upstate versus downstate, having participated in that process. But why isn't it the people's burden to prove that
If
they
we're-
don't have a license?
If we're talking about the comparative convenience test, it is, what I think is indisputable is that someone knows right away whether they have a gun license. It's not the type of thing that you forget.
But can you get to that test if it's an essential element?
Yes.
Okay, so tell us, if you would, what's the best case that supports that proposition, that comparative convenience could allow for that specific element not to be charged?
Morrison versus California itself. What that case said, it took out of the statute, unless the defendant raised the issue, occupational ownership of farmland by someone who was of a race that was ineligible for naturalization. And that was not a crime if the person was a natural-born citizen. And what the U.S. Supreme Court said was permissible was that if those other factors were proved, then the element of not being a citizen that burden could be shifted to the defendant. And the test it articulated was, the state shall have proved enough to make it just for the defendant to be required to repel what has been proved with excuse or explanation.
So
And that,
you did quickly pass through something that I found a little helpful, which is that in addition to licensure, there are other ways that somebody is entitled to possess a firearm publicly. For example, if you're a police officer, that's statutory exemption, right?
yes.
So, I mean, taking the defendant's argument here on this point to its logical conclusion, you might also then have to prove that the defendant was not a police officer and was not a federal agent, was not all the other things that are exclusions.
That is correct.
And that seems a little unreasonable.
I couldn't say it better myself. What I would also say is that in any given case, the circumstances, no one comes to court charged with CPW, just having walked off the moon. There are circumstances that are going to be presented as were presented here. And if those circumstances on their face suggest authorization, then it is a very easy thing indeed for a defendant to do, to say the people's case proves that I am authorized to do this, and the people then have the burden of disproving that beyond a reasonable doubt.
But I
If the
don't
circumstances-
I can't see, even with this question about then you'd have to disprove all those other bases for authorization, why that doesn't go just to circumstantial evidence. One would think an individual who's an officer would say so.
Yeah, indeed, one would think so, but this gets back to the Morrison test. If the circumstances do not suggest authorization for the conduct,
Okay,
which is criminally prescribable without authorization,
yes.
and the individual, then the state has proved enough to make it just for the defendant to be required to repel what has been proved with excuse or explanation. The defendant then says, I am a police officer, we naturally expect that, and then the people have to disprove that beyond a reasonable doubt. That is an orderly
That just
way.
strikes me as you have your circumstantial evidence, the defendant can choose to put up a defense or not. Jury can draw whatever inferences appear reasonable given the evidence presented.
Yes, and I'm saying that is,
But that's different from saying that they have to shoulder a particular burden.
what we're talking about, Your Honor, is a burden of coming forward. It is a minimal burden. I would point out that in People versus Anonymous, that's a 2020 case cited on page 22 of the district attorney's brief. The defendant made essentially the same arguments here about proof of licensure on appeal from a conviction for possessing a gun in a residence. The First Department observed, first of all, that the defendant is essentially raising unpreserved issues of legal sufficiency, statutory interpretation, and constitutional law. This court denied leave. The First Department also rejected the claim on the merits, remarking that the statutory scheme placed only a minimal burden on defendants to raise exemptions from prosecution in the first instance. This is like giving notice of an alibi defense. It lets the people know what's in the case and what is not. It operates, as Judge Halligan suggested, as a stipulation that the possession was in fact unlawful, and the people need not be put to the proof of disproving all of these types of authorization unless one
What about the jury instruction issue?
The defendant, by his own conduct, has chosen to remove that issue from the jury's consideration, and that is what how the burden of coming forward works here, and there's nothing unfair about that if the defendant is on notice of the need to do so, and the means to do so are easy.
Then you would have a conviction without a jury finding that the individual is unauthorized or has no license? Is that-
That is correct, but that is a result of the defendant's own conduct and the circumstances, under which he has chosen to let that case go to the jury. In this case, just as in People versus Anonymous, the defendant could have said, wait, you haven't charged the jury on my lack of licensure. His defense was, I didn't possess the guns. He's now saying, but in the alternative, if I did, they were licensed.
So you're saying it was a strategic decision not to request it?
And not to raise the argument, not to pursue the defense. This, again, the case parallels in this regard People versus Easley, where the defendant argued in the trial court that the victim of his sex offense was not incapacitated, and then argued that it was improper because the statutory scheme put the burden on him of establishing that he didn't know that the victim was incapacitated. His defense took that issue out of the case.
Just to go briefly to the burden of disproving each of these various, law enforcement officer. Let's say the people come in and they prove as an element unlicensed. You didn't have a license. At least in that situation, you've proved on its face what's a crime, what's not authorized, right? What's not protected conduct. Then I think you can say, okay, if you're going to come in and show an exception to the licensing requirement, that's more in the line of a defense. At least you have to raise it. But once you've proved unlicensed conduct, I don't see the need, arguably, to disprove every other exception to having a license.
I think the question is, at what point have the people proved enough to require the defendant to repel what has been proved? In this instance, first of all, the people's proof, in fact, established a lack of licensure. There's no way you can read this record in which, if he had a license, he would have been required to carry it with him. There's no dispute. He didn't have one, and then and the license
Where in
would
the
have been...
record specifically is the proof that you're referring to, if you would briefly elaborate?
Sure. I cited, it's cited in our brief, and I regret not having
It's in
the
the brief,
exact...
that's fine.
But his police interview was played, and he said about the guns, I didn't know they were there, I don't know anything about them, they're not mine. If he had had a license for those guns, it would have been specific to those guns.
So you're referencing the police interview which was played at the trial, is that right?
Correct.
Okay,
As
thank
part of
you.
the people's case in chief.
If they're not yours, you're not going to have a license for them, right?
Correct.
Yeah.
I can't get a license for something that is not my property.
I can't get a license for something else on my property, and if I had a license, it would be specific to that property. So if I have no knowledge or ownership of those guns, I can't have gotten a license for them. It doesn't make sense. And for that reason, we would ask that the court, if it were to find any error, would at most find that the error is harmless, and that is not an ideal case for this court to pronounce a broad new rule of constitutional law.
Thank you, counsel.
Thank you, Your Honors. Just briefly.
The
a
last
few-
word on a long day.
Yes, yes, last word.
Relish it.
Thank you, Your Honor. I don't want to talk too much about our argument. I think the court has articulated it, understands it. I would just point out that the Supreme Judicial Court of Massachusetts invalidated a similar scheme on almost identical reasoning.
There's a trial also, right, in Massachusetts?
Yes, I believe that was after a trial.
Does this analysis apply to pleas?
I'm sorry?
Would it apply to a plea?
I think it would apply to a plea, Your Honor, because the plea would be to the same elements. The plea would, in order to be convicted, the plea would just be to, I possessed a weapon outside the home, and that's it. I've done pleas, and they don't ask
In
about
that
license.
case, though, in this case, you've had a trial, and the argument would be the government hasn't met its burden of proof, and you got a verdict, and I think you're done, right? If you win, you're done. In a case with a plea, you just get your plea back?
Your Honor, I believe there's a case on this, and it's not coming to me at the moment, that talks about the applicability of this to a plea as well, and I'm sorry, I don't have it.
What would the remedy for a plea be? You get your plea back, or would it be, it's over?
Well, so you're talking about, obviously, convictions that are either on direct appeal or if it supports a collateral attack. So we're not talking about going forward, because going forward, if it's an element, it wouldn't be an issue. So if the plea is vacated on the ground that the defendant did not plea to an essential element of the crime,
You get your plea back, right?
I'm not sure, the people may be able to retry them again or go back to the original indictment, but going back to the original indictment wouldn't help them. They would have to retry him under a reformulated statute. The legislature would
Why
have to.
can't they retry him and prove that he's unlicensed?
Well, I think that a retrial that, under a reformulated statute, I think there might be ex post facto issues that.
The old statute, let's say there was a case where, even under the old statute, the people were put to the burden of proving this element, and the jury was charged that it was an element. But we're operating 5 years ago. Is that conviction okay or no?
So you're saying when they voluntarily decided to prove the element that we weren't required to prove? That raises a different set of issues. I think you're correct in that if they did gratuitously go ahead and say, well, we're going to voluntarily ask them to either plea to that element, but it doesn't solve the problem because the statute is facially invalid. So I don't think it completely solves the problem, and the fact that they voluntarily decided to do it in a particular case doesn't prevent them from not doing it in the next case. So the statute is bad, and the statute has to go. So I don't think that
And
would.
could we read Bruin to say that in order for you to be law-abiding, you have to be subject to a licensing scheme?
No, I don't think we can, Your Honor. Bruin in itself, in Justice Alito's concurrence, even says law-abiding people were forced to violate the licensing scheme because of when he was referring to the proper cause requirement. And so I don't think that they view mere non-compliance with a licensing statute to make you somehow a non-law-abiding person. Whether you're subject to whether you're ineligible or disqualified, that may be a different situation, but the mere fact of unlicensure doesn't make you a non-law-abiding person. I don't believe Bruin would find that as well. One final point with respect to the disproving exemptions. The authority to carry a loaded handgun in public does not derive from an exemption to a general prohibition. That's how New York currently is, but after Bruin, that's not where it comes from. The authority to carry a loaded handgun in public comes from the Second Amendment. So the state doesn't have to disprove all these exemptions. It has to prove that you're disqualified. So I don't think that we would have that situation here where they have to disprove all these exemptions. The authority derives from the Second Amendment, and then the state has to show why you're disqualified.
So would you agree then if they proved that you didn't have a license, they wouldn't have to disprove all the others? There could be a burden, at least, of production to come forward with evidence that I'm a law enforcement officer, for example.
Yes, I think I would agree with that, Your Honor. I think that a properly drafted statute could have in the first instance that the state has to prove possession plus unlicensure, and then I think that Bruin would allow for the burden to go back to the defendant at that point to rebut that presumption that they're not disqualified even though they didn't have a license. Yes. I don't know if, I know it's late, I did want to discuss the suppression issue. There's another ground for, dismissing this indictment as well because my client was subject to an invalid search. It's because the police did not follow their own procedures in conducting the inventory search. I don't think the people even dispute that he didn't follow the procedures to the extent, and we think that could be a per se unreasonable violation of the inventory search, even if they're arguing that the failure to follow their own procedures wasn't necessary because the Constitution doesn't require them to seek alternatives. We still think the search was unreasonable. My client hadn't even committed a crime, So the expectation of his privacy was not significantly lowered, and the justification for towing the car was, did not warrant, not at least asking him, where is the owner, and/or is there someone else that can drive the car? So I'd just like to make sure I mentioned that suppression issue as well.
Thank
No
you,
further
Counsel.
questions? Thank you, Your Honors.